Thank you for joining us for today's technology series presentation. My name is Milam Newby, and I'm a partner in the M&A private equity and venture practice in Austin, and I'm thrilled to be your host today. The purpose of the series is to provide helpful and timely insights on current issues and trends impacting the technology industry. The presentations, which we expect to happen quarterly, are intended to be interdisciplinary and cover topics relevant to participants throughout the technology group. Before we kick off today's presentation, an update on our last topic, which was titled Got Videos on Your Website? The majority of the cases filed under the Video Privacy Protection Act, or VPPA, are surviving motions to dismiss, creating substantial pressure on the defendants. In the instances in which a defendant has been successful in dismissing the case, the courts looked carefully at the, quote, consumer prong of the VPPA. What are you doing as a company that creates a consumer relationship? The Carter case out of New York has emerged as a leader in this area. We will continue to carefully study the field and to evaluate these cases as they make their way up to the circuit courts. Today's presentation on safe investments will be led by my colleague, Michael Gibson. Michael is also a transactional lawyer and partner in our Austin office. I'm now pleased to turn it over to Michael Gibson.
Thank you, Milam, and thanks everybody for joining us today to talk about safes, which I hope all of you have heard of. Maybe some of you haven't. And if you haven't, then this will be all the more useful. So first question, I guess the threshold question of this entire talk is, what is a safe exactly? You may have heard that term, you may not have, in the context of a capital raise or otherwise. So what is a SAFE? Well, it's an acronym, and it stands for Simple Agreement for Future Equity. And what that means in real human person talk is that it is a right to receive equity of a company in some future financing transaction. Specifically, it's a right to receive stock in a company in some future financing transaction. And one of the ways I like to think about what a safe is by specifically saying what a safe isn't. A safe is not stock in a company. It's specifically not a current ownership right in that company identified as stock. It's just a contractual right to receive stock in the future. It's also not debt, and this will come up a few times. It's one of the themes that I hope you take away from this. A useful comparison for a safe is a convertible promissory note, which maybe some of you have heard of those, one of those as well. It's a similar instrument with some important differences that, again, we'll talk about later. A safe is specifically not that. It is not debt. And importantly, there is no obligation under a safe for the company to actually give you your money back on some fixed date in the future if there hasn't been a financing event or a sale of the company. We'll talk about all of this in more detail, but a few things to orient you all about what is a safe and what does it do. So it's a convertible security, and the question that should be jumping into your mind is, okay, well, convertible into what, and convertible at what price? We already talked about it's convertible into stock, and we'll talk more about what that stock needs to look like. And then convertible at what price is the other very important question. And there are a variety of ways that a safe can set out what that price will be. The most common ways we'll talk about is a valuation cap or a conversion discount. Those are both, you should think about those in the context of what is the future financing that's triggering conversion of the safe, and what's the general price being charged for stock in that transaction. That another important thing to point out, the conversion of a safe into stock requires some affirmative act of the issuer of the safe. So that's the company. I'll keep talking about the company. I mean that as the issuer of the safe. There's no right for the safe holder to say, okay, I'm done holding a safe. I want to hold the stock. Just give me the safe. A little bit of the history of the safe, and actually some information on where you can find more information about the safe. So this is a relatively new invention as an instrument. It hasn't been around for that long. I think it's been around for about 10 years. It was developed by an accelerator called Y Combinator. And the idea was, look, we've got all of these super early stage companies that need to raise capital. They're not ready to do a preferred stock financing because that would mean having difficult conversations about valuation. Founders may not be happy with how low the valuation would be on their companies and therefore how low the price of their stock would be in that financing. So let's create a way that allows those companies to go quickly and efficiently raise capital in a convertible instrument that can delay that valuation discussion. And there was already a way to do that, which was via a convertible promissory note. But there are some issues from a company perspective in a convertible promissory note that again, I'll talk about, that led to Y Combinator thinking about how can we do a similar instrument in a way that's better for founders and easier for them to actually go execute on. And so they created a SAFE, started using it for their member companies, and eventually it caught on enough that they posted it on the website as a template for non-member companies to start using. And there are some very helpful annotations and narrative descriptions of how the SAFE should work in various financings on the website. But one of the great things about that is that there's a single standardized form with there are a few variations, but they're all available on the Y Combinator website. So feel free to go look at those at your convenience. One other thing to point out at the outset, especially for those of you who may have companies or represent companies that may be thinking about using a SAFE, these instruments do require board approval. And I'm assuming that this is a Delaware law or a Delaware corporation that's issuing these SAFEs. Any instrument that would result in the issuance of stock under Delaware law requires board approval. So just keep that in mind as you're thinking about these SAFE financings and how to document them. Okay, spending just a few minutes talking about valuation and price, because this is probably the key question in a SAFE investment. And that's, how much of this company am I actually buying for the investment that I'm making? That concept you'll hear described as valuation. If you ever hear valuation, just think about that as, what is the price that an investor is paying for the equity that they'll ultimately receive? One of the reasons why you would use a SAFE, as I mentioned, is to delay the point in time at which that valuation is determined. So delay the point in time at which the cost to the company of taking the equity capital is fixed. And the reason that both sides would want to do that is the company needs money. They need to pay employees. They need to go develop whatever it is that they're developing. I guess in our context, let's assume it's a software as a service business. They're going to hire developers. They're going to have some server time. They got to buy computers and maybe a lease. They want that money now. They need to develop their company. The investor is willing to give them that money now and may be willing to give it to them without setting a valuation on the company. But in return for that willingness to delay the valuation, they are going to ask for some benefit in return. So think about a scenario where somebody buys a SAFE for $1,000, the company gets the money, and that SAFE then converts into a financing in a year. And that financing in a year is at a fixed price. There's a new investor that comes in and negotiates with the company and sets a value on the business. If you're the SAFE holder and what you get in exchange for your SAFE is the exact same thing that investor gets a year later, that's not going to feel great because you invested much earlier, you took more risk theoretically. And so there are some goodies that are built into a SAFE to make sure that there are some incentives for an investor to want to make that investment early. And those are called valuation cap and a valuation discount. And I'll talk about those a little bit in a minute. One thing that's important to keep in mind is what form of safe we're talking about. So, and I won't spend too much time on this because it's a little bit of a history lesson. But the original safe form that Y Combinator put out, which you can still find and you may actually still see folks using, was called a pre-money safe. And it was called a pre-money safe because if there was a valuation cap expressed in that safe, it was expressed on a pre-money basis, meaning this safe can never convert into stock at a valuation higher than a $10 million pre-money valuation. There are some issues with expressing a valuation cap that way because you don't know all of the inputs into the ultimate pricing equation. Most importantly, you don't know how much the actual financing is going to be, and you need the amount of the actual financing plus the pre-money value to know what the post-money value is. And the post-money value is how you know what percentage of a company you actually own for a given investment amount. And so there was a Y Combinator and other practitioners recognized that this was an issue. And so they have changed the form to now be a post-money safe. And so when I talk about safes in this presentation, I'm going to be talking about a post-money safe. And what you should think about when you think of a safe and a post-money safe is that any valuation cap is expressed as a post-money valuation cap. And so if the valuation cap is $10 million, that means the amount that's invested in safes plus some amount of a future financing is the total value of the company. And you can therefore quickly do the math on what percentage of this company would a safe holder own if they invested a fixed amount of money into a safe with that post-money valuation cap. Another important thing to know about the post-money safe, and this is one of the other things that was cleaned up in converting or in changing the form to be a post-money form rather than a pre-money form, is that the safe instruments are treated as converting in their own mini financing round before the next financing. And so again, let's say we have $1,000 of safes outstanding. A year has passed. There's a new financing that's happening. $2,000 are coming into the company. For purposes of how the conversion works, the safes are actually treated as converting into equity of the company at whatever valuation the safe says you convert them in at. And then immediately after that, the new cash investors invest in the company. And so the impact of that is that the safe money is actually diluted by the new preferred equity investors. That money is treated as a later round, and that was not always the case with the pre-money safes, but it's very important to understanding the economics. Okay, one other threshold point to talk about before we get into some of the nuts and bolts of a safe is how are these documented? And so a safe is both an instrument and it is an agreement. As I said, you can go to the Y Combinator website and download one of these safes. But within that one single document is contained all of the provisions that would relate to a safe financing. Unlike, let's say, a convertible note financing where you may often see a separate purchase agreement that has things like reps and warranties, and then attached to it is a convertible note that has the actual economic entitlements of the investment. In a safe, it's all a single document. One outflow of that is that if you are investing in a safe in a company that has already raised preferred stock capital and it has existing stockholder agreements that may give rights to preferred stockholders, if you buy a safe, you are not immediately going to become party to those documents. You're not going to get those rights. That's specifically intended as part of the safe form. That's one of the benefits from a company perspective of doing a safe is you can just talk about a very narrow box of terms and kick any discussion about broader rights to a future time. And so just know that even if there are stockholder agreements in place that may give preferred stockholders certain rights, you wouldn't be entitled to those. It is still important, even though if you're investing in a safe, you're just signing up to the SAFE document. It is important from a diligence perspective to understand if the company does have existing shareholder agreements that may exist and that you may ultimately sign up to once you convert into stock. And that's because, one, it's good to know what other investors' rights are in the company. And two, if you do ultimately convert into stock, those documents are going to form the basis for whatever rights you have. They'll be negotiated in connection with the future financing, but they'll be the baseline for the rights that you have. So always remember to look at things like stockholders agreements, charters, and bylaws, even if you're not actually buying stock, just to make sure there aren't showstoppers or anything specific that your client would, if you're an investor, would want to have deviations from. I mentioned this earlier, but hit on it a little bit more. One of the benefits of the SAFE from an issuer perspective is that there's a standardized form available on the internet. And one of the benefits for a practitioner of that is if you receive a SAFE, if you're representing an investor and you receive a SAFE form, you can very easily run a comparison of that form against one of the Y Combinator forms and see whether the company has made changes to that may be beneficial to it. It really does. This is one of the areas that I think is actually a very attractive piece of using a SAFE if you're an investor or a company, is you can really streamline discussions about terms because everybody is familiar with the form. And if you're a practitioner that has certain things that you don't think are right about how SAFEs work in the Y Combinator form, you can know that you're going to be making those comments every time. You don't have to, again, to use a comparison to convertible note, you don't have to receive a draft convertible note and try to figure out, okay, which of the 10 or 15 versions of a convertible note that I've done does this look most like? Let me go compare against that. So that is a really good benefit of these SAFEs, is that there's more or less a single form that's easily comparable. One thing that is not part of the SAFE, and I'll talk a minute about some other things that aren't, is the concept of pro rata participation rights in a future financing. So that's the right to buy additional equity in a company. It's a pretty typical right in a private capital raise. That's not part of the form SAFE. There is a form pro rata rights letter that Y Combinator also developed to have, again, another form resource for investors and companies that want to enter into an agreement like that. And just know that is out there. The typical formulation for how that right would work is if you buy a certain amount of dollars in a SAFE, then you would do the math on, okay, given some specific conversion parameters, what would the fully diluted ownership of that capital be in the company post-conversion? And the pro rata rights letter would give the holder of that letter the right to invest that percentage of any future financing. One last point to talk about just generally on documentation is the idea of a side letter. So as I've mentioned, these SAFE documents are intentionally very standardized and have a set amount of protections for the investor and a set amount of rights. And I'm going to show you exactly what those are in a minute. If there's anything that the parties agree to that's outside doing things like changing valuation caps or changing discounts, frequently those are documented in a side letter, especially if they're things like extra governance rights or extra information rights. And so it's important to, if you're an investor investing in a company that is having a SAFE financing, it's important to keep that in mind. One, because just because something isn't in a SAFE doesn't mean that you can't ask for it. And two, it's also important to ask a company whether they have side letters with any of their other SAFE holders so that you can understand the actual full picture of the rights that they've given. You may want them to. One more point before we dive into the specific mechanics of the safe, I wanted to do a quick overview of the key differences between a safe and a convertible note. And if you remember one thing or one slide from today, remember this one, because in almost any financing where a safe using a safe is on the table, you could also just use a convertible note. And so it's important to remember, okay, what are the differences between a safe and a convertible note? If I'm a company, why would I want to use a safe? If I'm an investor, what am I giving up if I agree to use a safe and not a convertible note? So these, to me, these are the three key things that are the differences. The first is that there is no maturity date in a safe, meaning there's no fixed point in time at which the company has to give you the money that you invested back, or it needs to convert that money into equity. It just doesn't exist. You could invest into a safe you could invest today, and 10 years down the road, you could still be a safe holder. And if that company is still limping along, maybe you'll convert, maybe you won't convert. The convertible note with a maturity date gives at least some feeling to an investor that they somehow control their own destiny. If there's a 2-year maturity date, they at least know, okay, in 2 years, the company's got to at least come ask me to extend the maturity date of this note, or they've got to tell me things are going really poorly, we're never going to pay you back, and like, good luck trying to collect. Some investors think that's pretty useful and powerful in being able to shape a company's path, but the safe doesn't have that. Another thing that the safe doesn't have is any concept of interest. So if you receive a convertible promissory note, one of the core pieces of any note is that there is an interest rate. There is some amount of money that you're entitled to on the basis of the amount of time that the company has held the note. And that also does not exist in a safe. So going back to my example of if you invested today in a safe and you held it for 5 or 10 years, with a convertible promissory note, let's say that had an 8% interest rate, what you'd be entitled to receive from the company is your capital plus 8% interest over 5 or 10 years. With a safe, still just the capital. So it is it's an instrument that isn't designed for a long-term investment. If you're an investor, this should be something that you think is going to have a very short time horizon. The other key difference between a safe and a convertible note is what is the priority of repayment vis-a-vis other claims on the company. A convertible note is debt, at least on its face, it's debt. And so it would be senior to any existing stock of the company, including preferred stock, meaning if the company was sold before conversion, or if the company liquidated before conversion, and there's a pool of money that is available to satisfy creditors and to pay off any debt and to then hopefully distribute some cash to stockholders. If you hold a convertible note, you should feel comfortable, okay, I'm going to get my money back plus interest before existing stockholders get anything. For safes, that's specifically not the case, and they are to be treated as pari passu with any existing preferred stock, and pari passu just means they're treated on equal footing. So if you hold a safe, again, to use a $1,000 safe, and the company that issued you the safe liquidates, and they have some money to issue, and there are $2,000 worth of existing preferred stock, then your $1,000 safe and the $2,000 of existing preferred stock get mashed together for purposes of how much money you get back. And if there's only $1,000 available to split up between preferred stock and safes, then you'll get a third of that. You were 1,000 out of the total of 3,000. Very different from if you held a convertible note, you would have gotten your full amount of money back. Okay, so now we'll get into some of the real nuts and bolts of a safe in more detail. And this, while you're looking at this slide, this is just an overview of how I think about what are the key features of a safe. And I'll talk through each of these separately, but as you look at these, there are a few things I want to point out that are not included in a typical safe. As I mentioned earlier, any sort of concept of pro rata rights on a future financing, those are documented outside of a safe if they're included in the deal at all. But also things like information rights, not part of the safe form. So if you invest in a safe and it's outstanding for a few years, there's nothing in that safe document that gives you the right to ask the company for updates on, hey, how are things going in the business? Can I see your financial statements? That's not, if you wanted that, you'd have to specifically negotiate for that in a side letter. And it makes, if you think about the safe in the manner that Y Combinator developed it, which was as a tool for a very early stage company to raise really pre-seed equity financing, it makes some sense that things like information rights are not part of a safe, because it was either going to be one, a very short-term instrument, or two, an investment in a company that may not have financial statements that are really worth looking at. If it's a pre-development company. But as this safe document gets sort of extended in its use, and as folks start using it for bridge financings in later stage companies, these are some of the things that it is good to keep in mind that are not in the safe, so that if you are representing an investor that, for example, is a strategic or is the venture arm of a public company and needs financial statements to be able to do some accounting to filter into its publicly filed financial statements, you're going to need to specifically ask for that, because there's nothing in the safe that would give you that right. One other thing before I get to conversion economics, another thing that's not covered in the safe is any concept of board representation or board observer right or voting rights. And so voting rights make sense because, as I mentioned at maybe the very first bullet in this presentation, a safe is not stock. It isn't entitled to any of the rights of stock. And one of those rights is the right to vote on matters submitted to the stockholders. But frequently these safes represent most of the invested capital in an early stage company, and it, in my view, is entirely reasonable for a significant early stage investor to want some sort of representation on a board of directors, whether that's an actual board seat or a board observer. And keep in mind, the safe doesn't have any sort of concept like that. And so if you are investing in a safe and think that you should have some board representation, you need to cover that in a side letter. So to walk through the conversion economics in a bit more detail, the safe lays out a formula for how conversion is supposed to work. And again, this is conversion into a future equity financing. And as a general matter, the rule is you convert the safe dollars convert into stock in the next financing at a price that's equal to the lowest cash price paid by the investors in that new financing. So whatever the price that the future investor pays is, that's what you pay. And this is how the concept of delaying the valuation comes into play in the document, is by saying that the conversion price is the price that the future investor pays. Now that's just the baseline. And as I mentioned earlier, if you're investing in a safe and you're not going to actually convert into stock until some future financing, you're likely going to want some benefit for having made that early investment. And remember, there's no interest rate, so you can't even rely on the interest rate there. The two ways that are typically negotiated to give the investors that form of a benefit are a valuation cap and what we call a valuation discount. A valuation cap is a fixed post-money value at which the safe could convert. And so that could be a number like $10 million. And the meaning of that number would be, even if the investor in the financing that causes a conversion of the safe negotiates with the company that the company is worth $100 million, so that the equity is worth $100 million, your safe doesn't convert in at a $100 million valuation, it converts in at a $10 million valuation. So you are paying 1/10 the price, roughly, as you would if you converted in at the valuation in the actual deal. A very significant economic difference. A discount is a completely different concept, which is trying to get to, again, the same point, giving some benefit to the safe holder for investing before the actual financing event. And that discount is expressed as a percentage discount to the actual valuation price. So if the valuation, again, was a $100 million valuation, and if you did the math on what that meant as a price expressed as a price per share, and that was $1, a typical valuation discount would be a 20% discount. And so a safe would say your conversion price as a safe holder into stock in the financing is not $1 a share, it's 80% of $1 a share, or 80 cents a share. And the impact of that is you're getting 25% more equity for the same price as compared to the cash investor. You'll also see a better of formulation that combines these two concepts, and that the way that works is you say, okay, I have this safe is entitled to a valuation cap or a discount. And again, these would both be expressed as fixed terms. So let's say it's a $10 million valuation cap and a 20% discount. And on conversion, somebody's got to do the math and see, okay, which of these two methods gets the lower price for this safe holder, and whichever one gets the lower price, they get to use that method. So that was the economics. Now let's talk about the mechanics. How does a conversion, I keep talking about conversion into stock, how does this actually happen? So what the safe says is that a conversion happens automatically, and it happens automatically upon the occurrence of a financing event that's called an equity financing. That's a defined term in the safe. And in the form safe, that equity financing defined term only requires that it be a capital raise for preferred stock at a fixed valuation. So any capital raise for any preferred stock, as long as it's at a fixed valuation, that would trigger conversion of the safe into that preferred stock per the terms of the form safe. What the form safe specifically doesn't contemplate is that equity financing has to have a certain look or feel. So specifically, it doesn't say it has to be for some minimum amount of capital. It doesn't say that it has to be for preferred stock that is senior to or pari passu with any existing preferred stock. Those are pretty important points. If you're a holder of a safe, or at least I would want to feel comfortable that a company couldn't raise a very, very small equity financing on favorable terms to the company that triggered conversion of my safe into a really bad security. And that's not the intent of the Y Combinator form, but it's certainly something that could happen, and something that if you are a savvy investor, you should try to avoid by changing the terms of the safe from the Y Combinator form. Another important piece of that automatic conversion is that it's automatic, meaning the company doesn't have to come ask you for permission to take your safe, throw it in the trash, and give you the stock that you're entitled to from the financing. And what that means is that financing is going to be negotiated by somebody else on terms that are acceptable to somebody else, and on terms that you may not like. But that's what a safe is. That's part of the deal. And the safe form doesn't provide any sort of comfort to an investor that future financing has to be on terms that it's happy with, or that the investor would receive rights upon conversion that they're happy with. Just to move on to the next point, the rights on conversion that you would receive as a safe holder are just whatever rights the conversion stock entitles you to in the next financing. And again, those are going to be negotiated by someone else, and the safe form doesn't have any sort of protection or guarantee on what those rights might look like. Although if you've done enough venture financings, especially in the technology space, you'll know that there is a separate set of form documents out there called the NVCA preferred stock financing documents that are not always used as the basis for a preferred stock financing, but some version of them or something that's close enough that you, as a safe investor, you may have a pretty good idea of what those rights might be. Last point to note on conversion mechanics is that while conversion is specifically automatic, again, meaning the company doesn't have to come ask permission from the safe holder, the safe holder is, per the terms of the Y Combinator Form Safe, required to sign whatever the financing agreements are that are entered into in connection with that conversion financing. And there are very limited guardrails in the safe form about what those financing agreements could say, or what they couldn't say, and still require a safe holder to sign up to them. So while it is not typical or customary, it's possible that a set of financing documents could include something like a non-compete clause that says, as long as you're a stockholder, you can't compete with the company. And just per the terms of the safe and the form exists on the Y Combinator website, there's nothing that would prevent a company from imposing that on a safe holder as an automatic or as a condition to the automatic conversion of that safe. Not typical that you'll see that, but certainly within the realm of possibilities that if you don't specifically negotiate for that protection, you may end up in a pretty rough spot. So I just went over what happens to the safe in connection with an equity financing that triggers conversion. The safe also contemplates a couple of other scenarios where there isn't a financing event that triggers conversion, but it is still an event that necessitates some treatment of the safe. So specifically, those two events are a sale of the company or a liquidation of the company. Sale of the company is straightforward enough. Liquidation of the company, think about either the company has failed and is winding up its operations and theoretically distributing some capital back to investors that's left over after satisfying creditor claims, or it's sold all of its assets and then again has a pool of money to send out to investors after paying off creditors. So those are the two non-financing event scenarios that the safe form covers. On a sale of the company, the safe form says that the holder of a safe just gets its money back. So if you, again, invested $1,000 in this safe and the company sells to a third party, let's just say via a merger, before your safe is converted to equity, you just get your money back. Or if your safe had a valuation cap as part of the terms of the safe, then what the safe would say is you get your money back, or if we assume that you converted to common at the valuation cap before we did this sale of the company, if you would have been entitled to more money as a stockholder, then you get that amount of money. But in general, you just get 1x your money back. And that, as I mentioned earlier, that 1x your money back is on a pari passu basis with any other preferred stock. Liquidation treated the same way with the same seniority. What there isn't is any sort of a concept of a premium to the capital amount that you invested, which is a relatively common concept in a convertible note financing, that if there's a sale of the company that occurs before conversion of the note, you don't just get your money plus interest back. There needs to be some extra benefit to you for having invested dollars in this company, because if somebody is taking their hard-earned money and investing it in a private growth company, I can promise you what they're not expecting is a 0% interest rate. You get your money back in 5 years investment. There are a lot of different securities that you can go get that are a much more attractive risk profile than a private company equity investment if all you are looking for is just to get your money back after some amount of time. And so these convertible notes will frequently pay some sort of respect to that concept by saying, if we sell the company before you get to convert to equity, you don't just get your money back plus interest, we'll also give you a premium payment. And frequently that's another 1x the principal amount you put in. Safes don't have any sort of concept like that. You just get your money back. And again, if you have a valuation cap, then maybe you get the benefit of a valuation cap. Last point on sort of non-equity financing events. If you do negotiate, as I was potentially suggesting you might want to as an investor, for some sort of a dollar threshold on the equity financing raise, meaning the company can't just issue $1,000 worth of preferred stock and convert me. It's got to at least be a financing that raises $5 million. Pick your number. If you have some concept like that in your document, then it becomes possible that there could be a financing event that occurs where preferred stock is issued or common stock is issued or something else is issued, and your safe doesn't convert because you negotiated for a minimum financing amount. And in that case, there would also be no optional right to convert unless you negotiate for that. So something to keep in mind if you do put a threshold on the equity financing amount, is you may also want to include the right to optionally convert if a financing happens on terms that don't meet that threshold. Next point to talk through, what are you actually going to receive once this safe is converted? So the preferred stock, we've talked about that. It's the safe is the right to receive the stock that's issued in a future financing, and that is specifically going to be preferred stock. And the baseline is that you're going to receive the same preferred stock that's issued to the cash investors in that conversion financing. So whatever they get Series A preferred stock. The safe holder gets Series A preferred stock. However, once you start talking about valuation caps and discounted valuations, that raises the very likely possibility that you're actually, as a safe holder, going to be paying less per share than a cash investor in the preferred stock financing. That's the entire point of having a valuation cap or a valuation discount, is that you get a cheaper price. And there is an issue that is created because of that mismatch. And that issue is, let's just use excuse me, let's just use the valuation discount because it's easier to think about. If you're entitled to a 20% discount on conversion and a preferred stock financing happens, and let's say that preferred stock financing happens at $1 a share, the price that you would pay as a safe holder on conversion would be 80 cents a share. However, in the charter of the company, which would need to be amended to create this new preferred stock, if it's anything like a typical set of venture capital financing documents, that charter is going to specifically include what the price per share was for that share of stock, which is going to be $1. And that $1 figure is going to be the reference point for any sort of economic entitlement you have in the company. Most importantly, being the liquidation preference that you're entitled to and anti-dilution adjustment entitlement you may have. We'll focus on liquidation preference because it's the easier example. Let's say that you had a 20% discount, so effectively you paid 80 cents per share rather than $1, but the charter says you paid $1. that creates an economic mismatch because you held shares as if you paid 80 cents and yet you're entitled to $1 on a liquidation as your liquidation preference. If you do the math, it means you're entitled to 25% more liquidation preference relative to how much you actually invested compared to a cash investor. And so to solve that issue and to get everybody back on level terms, meaning if I invested $1 and somebody else invested 80 cents, then they have an 80-cent liquidation preference and I have $1 liquidation preference. A typical tool that companies use is a tool called shadow preferred. And the SAFE form refers to this as safe preferred stock. And what safe preferred stock does is it says, okay, if you convert in at a discounted price to the overall preferred stock financing price, you don't get exactly the same preferred stock as a cash investor. You get exactly the same preferred stock as a cash investor, except that your price per share for things like a liquidation preference entitlement is tied to the amount of capital you actually invested, i.e. it's tied to your effective conversion price. So that's shadow preferred. You'll hear that in a lot of different contexts. It's not a difficult concept to understand, but it does seem to vex people. One other point to quickly talk about, the SAFE form does include some very limited reps and warranties about the company. It also includes some reps and warranties from the issuer, but those we don't need to spend time on. They're your typical private placement investor reps. The company reps are more interesting because they're really limited. There's not a lot of meat on the bone, so to speak, on the reps and warranties about a business in the SAFE form. Specifically, and I give some examples, but specifically, there's no rep about whether the company has debt, which you probably would care about if you're investing in a private company because that debt's going to be senior to you. You may want to know how much is outstanding. No representation about litigation, no representation about financial statements. So there are some really fundamental things that could be wrong with the business you're about to invest some money in that you're not going to have protection on if you don't negotiate for it. And we'll talk about that a little bit more in a second. Last point on the form itself, just to point out, and I'll just talk about amendments because we're running short on time. The general construct in a SAFE document is that SAFE document can be amended by not just the holder, but the majority of the holders who invested in the same form of SAFE. And so there are some guardrails, which I list on here, but just keep in mind, unless you specifically negotiate that you can't amend my SAFE without my consent, it's entirely possible that a company and some other investors can do that without your permission. Two things that I wanted to cover as a little bit of a deeper dive, things that come up very frequently in these SAFE investments to close this out. And that is, what do you do if there are multiple different SAFEs in existence that have different economics? And then how should an investor think about diligence in a company where they're making a SAFE investment and the interplay between that diligence and the reps and warranties? So first on coexisting SAFEs. Just to back up to the history lesson, one of the reasons that the SAFE was developed is that it is specifically intended to work really well in one-off issuances. So a company can talk to investor number one and agree on the terms of the SAFE that investor number one is going to invest in. Simultaneously, they can be talking to investor number two and agree on completely different conversion pricing mechanics. And those two SAFEs will work together for the most part, subject to one of the points that I'm going to talk about. And that happens all the time. That's a very frequent occurrence in these SAFE financings. Is investor A may get a $10 million valuation cap, and investor B, who invested 6 months later, may get a $20 million valuation cap. A couple things to just keep in mind now that you have it in your head that that is a possibility. One, especially if you're using a valuation cap as part of these deals, you really need to actually sit down and do the valuation math on what percentage of the company will each of these safes be entitled to, and what percentage of the company will be left over for the existing shareholders to keep on conversion. And usually the math works out if you're dealing with a post-money safe, but it's entirely possible that if you raise too much money, or if someone didn't pay attention to how all the safes work together, you could actually break these investments and make it so that they can't actually convert without going back out to everybody and getting everybody to agree to some sort of an adjustment to what they're entitled to. So it's always important to actually do the math. Another thing to keep in mind is if you're investor A that invested with a $10 million valuation cap, and investor B, instead of getting a $20 million valuation cap, they got a $5 million valuation cap 6 months down the road, all of a sudden that doesn't feel very good as investor A, because the later investor got better terms. They got a lower price than you'll pay on conversion. And so how do people deal with this? Well, they deal with this by negotiating for most favored nation treatment. And what that means is a contractual agreement by an issuer of a safe that says, if we give a new safe holder better economic terms than we're giving you, we will offer those terms to you, and you have the right to take them or not. Obviously, this is something that would always be fantastic for a safe holder, but issuers will resist, and I think rightfully so, because one of the values of a safe is the ability to go do these one-off terms with one-off investors. But again, most favored nation treatment, a good way to solve that problem if you're on the investor side. Last point that I wanted to cover as sort of a wrap up, and it is zooming back out to the overall picture of what's happening in one of these safe deals. You've got an investor that is going to put some cash to work inside of a private company, and they're going to, with the expectation that that cash is going to multiply in value, and they're going to get some home run level return on their investment. Meanwhile, we've already talked about how the safe form has very limited reps and warranties about the business that they're investing in, and doesn't have a lot of protections for the investor around how the money is spent or how the direction of the business is going. So there's a natural tension between those two things. To add to that tension, one of the reasons that an issuer may like to use a safe is because they see it as an easy and quick way to raise capital. And part of easy and quick for issuers is not a lot of due diligence. And a lot of issuers come into a safe financing round with the expectation that there's not going to be a lot of due diligence. They're not going to have to answer a lot of questions about the business, or not going to have to do disclosure schedules. And in some cases that bears out, and that's how things go. However, as an investor, know that if you are doing that deal with limited reps and limited diligence, there's not really much protection at all for you from having invested on a fraudulent basis or a misleading basis. There's just not. And there's the practical side of that, which is these are growth stage companies, and they're either going to succeed or they're not. And if they succeed, this is unlikely to be meaningful, and congratulations, you got away with doing limited diligence. But if they don't succeed, it's a pretty narrow set of circumstances where there's actually money left over to give you anyway. And so I think that is one of the reasons why some folks get comfortable with doing limited diligence and getting limited reps, is because they think about the fact that there may not be a practical remedy at the end of the day anyway. But it is, as an investor, it's important to know that if you go into one of these businesses in a safe and you don't get meaningful reps and warranties and you don't do due diligence, it's a pretty risky thing to do. One of the ways, and I'll just close with this, one of the ways that I like to think about reps and warranties and how they interplay with diligence in a company, let's just assume that this is a very early stage company that's issuing a safe, is that those reps and warranties are really supposed to bolster or even stand in the place of a more fulsome diligence exercise. And so if you make sure that this company has to somebody at the company has to specifically sign a safe document that says, yes, I can represent that there is no debt. Yes, I can represent that there is no litigation. Just going through that exercise may prompt discussions that will let you know about significant, maybe not so significant issues in the business, but at least you'll be aware or more aware of the state of facts and the state of the business that you're investing in. So that was everything that I wanted to cover. Hope that this was a useful overview of what a safe is. I hope that for those of you who were not super familiar with the safe, that this demystified what the safe was in some ways. But I guess in closing, thank you all for coming. Feel free to reach out for questions. Milam, I don't know if we had questions. We may have a couple of minutes for them if we did.
Yeah, let me, Michael, I'll run through a couple. First, logistically, we will make the slides available after the presentation. They should come out with an email, as well as there'll be ability to access the presentation as well. There was a question, Michael, about when Y Combinator made the shift from pre to post valuation. Was in 2018. For those interested, there is sort of a helpful user guide and sort of background on the safe on the Y Combinator website. So feel free to look at that. Michael, question for you. Baseline view, are safes investor friendly or company friendly?
Company friendly, no doubt. That was a softball.
Yeah, we got to lead them up well. Michael, there were several questions around tax and accounting treatment for safe. And obviously, we'd caveat this by saying you ought to talk to your own tax and accounting advisors. But what's sort of the general, if you're aware of the general thought on how safes are?
It is. The safe is specifically and by its terms intended to be an equity instrument for tax purposes. I know the tax folks, there are differing opinions about how that should be treated, but on its face, that is what it is supposed to be, as an equity instrument.
And then last question, Michael, do directors or officers of a company owe any sort of duties, I guess specifically fiduciary duties, to safe holders?
Yeah, so I think in Delaware, I would say the answer is no. They're not a stockholder, and the board of a Delaware corporation owes its fiduciary duties to the stockholders of the corporation or the corporation itself. So in Delaware, I'm comfortable saying no. I think that probably also be the case in a place like New York. But no, now that's setting aside any sort of fiduciary duties that can be triggered by zone of insolvency if you're dealing with a jurisdiction that still has those sorts of concepts. But as a general matter, you should not, if you're investing in a safe, you should not take any comfort in the fact that a company may owe you fiduciary duties, because I think it's likely that they don't.
Well, great. Well, thank you everyone for attending today's presentation. The current slide shows the next two sessions we have upcoming next in September, which will cover antitrust issues within the technology industry. And in December, we'll do an overview of issues with commercial technology agreements. We're also finalizing our calendar for 2024, and we'll announce dates and topics for 2024 in the next few weeks. Thanks again for being here, and have a great day.